All right, let's get started. So, hello and welcome to the Family Law Now live virtual event series. Thank you for joining us today for Blurred Lines, When Children's Maturity, Capacity, and Privacy Collide. This event has been accredited with 1 hour of professionalism. Today, the panel will discuss why the legal landscape is so complex, maturity versus capacity, core problems, what providers are saying, why confusion persists, translating the law into practical guidance, drafting effective court orders, managing client expectations, safety-focused decision-making, family violence and coercive control, and recent case law. As always, we encourage you to use the Q&A feature throughout the event. All the resources mentioned today will be included in the show notes, which will be received via email later this week. I will now introduce our panelists, Andy Inkster, Susanna Crichlow, and Mark Simpson. Andy Inkster is a lawyer in Ontario who runs his own boutique firm, Inkster Law. Andy's practice focuses on parenting disputes, often in the context of family violence and coercive control. The intersection of family law privacy, capacity, and health law is a major professional interest. Andy's professional background in healthcare, providing professional development for healthcare and legal professionals working with families. This background helps him bridge the gap between how family law and health law understands medical decision-making. It also informs his work supporting legal and healthcare professionals in learning from each other. Susanna Crichlow is an associate lawyer who is fully trained in collaborative practice. She has over 13 years of family law experience and works hard to achieve favorable outcomes for her clients in their family law cases. Susanna approaches the client consultation with a compassionate but analytical mindset and endeavors to provide her clients with the very best representation possible. She is also passionate about supporting local and international charities and humanitarian aid organizations, including World Vision International, ERDO, and the Salvation Army. Mark Simpson is an associate lawyer at Russell Alexander. Mark draws on 2 decades of experience in trials, mediations, and arbitrations to deliver result-driven outcomes. He is proud to share he recently completed his collaborative practice training and is excited to start working on collaborative cases. He currently serves as principal to the firm's articling student and sits on the board of the Middlesex Law Association. He serves his community on boards. Away from the office, he enjoys coaching baseball at all levels and is OBA certified. He believes that stamina and focus are essential to navigating the dynamics of family law cases. He is passionate about health and fitness. I will now hand things over to our speakers to get started with the presentations.
Good afternoon, everyone. So it's Mark and I are supposed to start with the legal landscape here. And I'm coming from a family law background. So I want to flag a few things for folks that you may not be familiar with or that people tend to miss a little bit is that the Family Law Act and the Divorce Act have very specific provisions for decision making that we're very aware of. But where this, in my view, where this tends to fall apart is the other legislation this interacts with. So there's the Healthcare Consent Act and the SDA, the Substitute Decision Makers Act of Ontario, and those two pieces of legislation interact with family law in a very interesting way. I can let Mark talk more about the specific cases we wanted to discuss if you're open to doing that, Mark.
Don't have any specific cases. I think we're just for the intersection between the family law legislation, which is the Divorce Act and the Children's Law Reform Act, and the privacy legislation as well, including the there's provincial, municipal, and federal privacy legislation. The area is complex in the legal landscape because we have basically differing substances for which the legislation is purporting to deal with. The family law legislation is intended for the purpose of providing rights to parents, not to the particular child in play, or children, whereas the child or children who may be attending school and may have private school records, may have IEPs, may be seeking medical treatment from certain doctors, hospitals, or may be attending with therapists and counselors. Their interests tend to be more, in terms of the privacy interests, tend to be more governed by this interacting privacy legislation. So at the end, the first topic, as far as the legal landscape and why the area is so complex, is that within the family law case itself, parents are not going to family court to ask for the child to have certain rights of disclosures of information. Instead, parents are going to court to ask for access of right of information, which is generally understood amongst family council to be something that is customary and usual to be included into a family order. However, depending on how the terms of that order is drafted, it may or may not deal with the rights and provide the guidance that's necessary for purposes of the parents getting the information from an institution, school, medical, hospital, etc. Um, do you have anything further to share on that, Andy?
Yeah, I think it's just saying that I think that's a good overview, right? It's that there are these different pieces of legislation. We have our legislation. Parents have the way that they're used to dealing with things, and then the organizations are not necessarily alive to the provisions of the Family Law Act or the parenting legislation we're using, right? So then they're thinking more of the privacy aspect in the Healthcare Consent Act. So I think where this really comes together and the reason for the complexity is that it's this overlapping legislation, but it's actually on the ground where the problems happen. Um, Should I just jump to our next topic, the capacity maturity spectrum?
Yes, should we spend, is this an appropriate area to spend just a brief overview with respect to the interconnection between these differing privacy legislations and the differing institutions, or will we be doing that in a little bit?
Yeah, I mean, I think that makes sense too. So it also makes sense to kind of just deal with it practically, right? Because we're thinking about, yeah, sure. I so main the main way these different legislations work is that information sharing, this is where it comes up a lot in my practice, information sharing is regulated through the privacy legislation. And there's different overlapping pieces of privacy legislation that are sometimes kind of similar. Each one has its own provisions, but there's kind of a common matrix where once somebody has the capacity to consent to something or the capacity to decide something, the information disclosure that goes along with that is often within that person's control and not the parent's control. So that's where, in my experience, it falls apart and where there are legislative gaps between them. And there's, I think, still an ongoing debate about, there's still discussions being had about which legislation works with what other legislation, how they work together.
I think we were going to next get into the maturity and capacity, the two concepts of maturity and capacity.
Yeah, for sure. So maturity is the concept that we talk about a lot in family law. And capacity, though, there's a presumption of capacity in Ontario. So that means that we presume someone is capable of making decisions. The age that that starts is 16 for personal care, but for healthcare decisions and other decisions, it's often viewed that children, well, and it's properly viewed that children have the right to decide about their own medical treatment once they have the capacity to make that decision. And the person assessing that capacity is going to be the provider. So when a child's enrolling in therapy, for example, or counseling, if they're non-consenting to counseling, the provider may not provide that service. The parents can't push a kid who's refusing into counseling. And that, I mean, on its surface, that seems quite intuitive, right? But when it comes to other healthcare decisions, that can get a little bit blurry. So capacity and maturity, I think, are linked, but capacity has more resonance when you're talking about adults, and maturity tends to be the term we use when we're talking about children. In my mind, they're not necessarily different ideas. I see them as one continued spectrum. And as we see more and more situations involving adults. We see more and more high conflict situations with very young adults or teenagers and kids who are enrolled in counseling and that kind of thing. And we'll get into that when we talk about our specific cases. This issue comes up where people perhaps underestimate what decisions a 9 or 10 or 11-year-old can be making for themselves.
Just to add to that, is it fair to say that capacity is the child's ability to understand the information and consequences regarding the release of certain records and information?
So this is a little bit tricky. Yes. So the Substitute Decision Makers Act says that there are two components of capacity. So one is the capacity to understand information. So when that comes to financial decisions, we do have an age for financial decisions, a clear age at 18 and 16 for certain contexts. But for personal care or decisions about treatment and information sharing, the challenging piece here is the second arm of that test, the capacity to appreciate. That's more complex. That involves social skills, that involves an understanding of how institutions work, that involves an understanding of mechanisms. So understanding that if I say yes, someone will get this information is different than appreciating the consequences of that. The consequence may be that if you say no, they don't get the information, but also you don't get enrolled in this program. So that piece is much more nuanced. It's much grayer. And I believe it's harder for lawyers and for healthcare providers to really understand someone's ability to appreciate the consequences of a decision.
Is it too simplistic to describe it in the way that the healthcare provider assesses the capacity of the child, whereas the family court judge will assess the maturity of the child's views?
Yeah, I think that's reasonable. And I think that the two concepts are definitely overlapping because as a child becomes more mature, the presumption of capacity means that they are presumed to be able to make the decisions that they are making, right? So that's where it gets complex. Can a 2-year-old decide about what the parenting arrangement, what the parenting time should be? No. Can an 11-year-old decide that? Probably not. What about a 13-year-old? What about a 13-year-old with disabilities? What about a 13-year-old who's experienced domestic violence? This is where it breaks down a little bit. How is that, how are we doing that? And, in my mind, a views and preferences report, a voice of the child report can be helpful, but we know that that doesn't necessarily speak to the child's ability to understand what that parenting time arrangement will mean for them. Is that a very long way to say it depends?
Any
Not
magic
really.
cages?
What
So,
was that? You cut.
is there any magic ages with respect to capacity or maturity, or is it on a sliding scale?
I get asked this a lot. I often get asked about what about 14? What about 14? I don't know what about 14. I don't know where that comes from. I'm very open to hearing from folks who do know where that comes from. My personal belief is that it's from an old version of the CLRA that's no longer in effect. There's some guidance in the CYFSA about ages, but there is no magic age for many decisions. Healthcare specifically, no magic age. And ultimately, I think we need to be thinking, bluntly, less like lawyers and more like people. For those of us who are parents, it's very important that we have children's consent, their body, their choice. So when we're thinking about, setting a child up for a fear of vaccination or a fear of the dentist or anything like that, making sure we have their consent and making sure they understand the procedure should happen at every age, whether or not we believe that child can understand it or not.
For our 81 participants and growing, the takeaway here then, as a family lawyer, would be to, if they're assisting a client, to ask for records from a medical provider, hospital, school institution, etc. They would have a conversation from the perspective as far as whether that provider has engaged in a review or a capacity review from the child in relation to the disclosure. Is that
Yeah, I
fair?
think we can talk about that when we talk more about like what providers are saying, right? But I think ultimately, I think we do that. That's an important point because when we were planning this talk, we talked a lot about information sharing. We didn't talk so much about decision making, and that is a very important piece. And setting clients' expectations and saying, you may have an order that says you have decision making responsibility, but you need to understand that your child is not a party to that order, and a child has the ability to make decisions. A provider can't provide treatment. So that's what the Healthcare Consent Act says. A provider cannot provide treatment to someone who is non-consenting without more, right? So in that situation, the healthcare provider is doing a capacity assessment It's not a capacity assessment in the meaning of the Substitute Decision Makers Act. It's not a formalized clinical opinion of someone's capacity, but it's an on the ground moment where the provider says, does this person in front of me understand? And if they don't, they're committing a criminal act. So I think for us, having that knowledge of what a healthcare provider's training is around informed consent is very important, right? So their training is to respect someone's autonomy. So if there's a court order, for example, something like a psychoeducational assessment, we all have done that order. This is not an extreme situation. The party shall collaborate to obtain a psychoeducational assessment. Well, if the child refuses, right, it's not happening. But, having that initial conversation with the client of, I know you want your child to be ordered to do X, Y, and Z. However, if they are not agreeing to it themselves, that's a different conversation than if you're not agreeing with your ex about it.
I think the next is identifying the core problem where breakdowns may occur in practice amongst conflicting statutes and consistent interpretation and any gaps between legal principles and real world application. Susanna, do you want to
Thanks, Mark. I think this discussion leads nicely into the core problem, right? Because that's what we've been discussing all along. And in the case of AM and CH 2019 ONC 764, the judge puts it nicely. We can make orders, but then you get to the health practitioner and they say no. And then what do? Family court cannot solve all of the problems. And in a lot of cases, we have not successfully managed our clients' expectations. They think that they have an order. They think, yeah, we're going to agree to therapy. The provider is going to release the notes. The judge is going to have the notes. The judge is going to see that one parent is not agreeing to the therapy, or the judge is going to try to figure out the core problem. But you get to the point where the therapist says, well, the child isn't consenting. So what do? The Divorce Act, Section 16.4, specifically allows a judge to make a variety of orders. A therapeutic order is one of them, but it says subject to other legislation. The CLRA, Section 28, does not say that, but it doesn't mean that there isn't a roadblock there. So part of the problem is explaining to our ability to explain to our clients that these are the roadblocks they're going to run into, and then trying to find creative solutions around those problems. How do you get the child to consent to therapy? And if the child doesn't consent to therapy, then what do? Have you been able to come up with creative solutions, Andy? I know this is a major part of your practice.
Yeah, so let me flag that one section of the legislation why it doesn't say anything. So it's not that you don't know this, it's just that I want to highlight it for folks. The reason the Divorce Act says that explicitly is the issue of paramountcy. It's federal legislation, right? So
Yep.
it does say, and we talked about this earlier where you were saying, well, why doesn't it override? And this is why, right? Because the other legislation is provincial. So the Healthcare Consent Act, the Substitute Decision Makers Act, all of those are provincial. Then so the CLRA could do a better job, in my mind, of flagging that issue, but we're lawyers. We need to know the entire law. I mean, maybe not every single thing, but we should really know how these pieces of legislation intersect, right? So to that point, I think, at the end of the day, we've all done it. The parties shall, et cetera, and everyone will be reasonable. Well, if everyone was reasonable, we wouldn't have jobs, right? We all know that. So no, people are not reasonable. I think that you think about how defensive you need to be. And are you in a very high conflict situation where your client needs to be protected? The other side is going to, argue that they didn't do what they needed to do. They're going to bring a contempt. They're going to bring motions to enforce. Who knows, right? You need to know what you're dealing with. And if you're in an incredibly high conflict situation, Or just best practice is to make sure that that order says the parties will cooperate on, make sure that you're not binding your client to something outside of their control.
Yeah.
And maybe if you have OCL representation on your file, maybe they have something to say about it too, right? If we're getting into very complicated, very high conflict, ongoing medical decision making that has to happen and a child's not consenting, maybe you're in the wrong venue, right? Like thinking about what you're doing and why you're doing it. But I think for the run-of-the-mill typical things, what we're looking at is making sure that the orders say the right things and that we're not binding our client to things they cannot do. So the one I see a lot is one party saying, well, I asked for the therapy treatment records and the therapist said no. And my ex-partner was supposed to sign the consents. So clearly they didn't. And I say, well, handled it myself, made sure the consents went through my office. I have a copy of it. The consent was signed. What else can I do here? Right. So
Mhm.
then I think, we can't count on therapists to explain why it's not being released. So saying, in negotiation, making sure that opposing counsel understands that your client is going to sign the consent, but that the provider still has discretion,
Mhm.
making sure your order includes subject to other legislation, which is this clause from the Divorce Act.
Yeah.
Uh, because even if you're under the CLRA, if your parties are not married, that legislation doesn't trump the privacy legislation. And there's different, I mean, we talked a little bit about this before. There is different privacy legislation depending on the nature of the decision. So MFIPA is the municipal privacy legislation. The Education Act has components. The CYFSA has components of privacy and disclosure. The healthcare, I always forget exactly what the acronym stands for, but the Protection of Health Information, et cetera, Health Promotion Act. As a former health promoter, I really should be able to rattle it off, but the PHIPA,
Yeah.
it has specific provisions about disclosure and privacy. And I don't think that most of us know what every single piece of legislation says exactly. They're all slightly different. Uh, but flagging for our clients, providers will release information that they feel they can. And if you're on the side of the party asking for disclosure, which is rarely my side, so I'm less familiar with that client management dynamic, but setting expectations, saying, we can pursue disclosure, but that doesn't mean the therapist will give the information. And so being really clear with folks about what we can and can't disclose because it's not within our power and it's not within our control.
I have this issue sometimes when you talk about Section 7 expenses, right? Parents say, well, I can't disclose the cost of tuition, for example, post-secondary expenses, because that information is within the child's control. That information is an adult. And I've had judges who've said, well, you're the parent here asking for contribution. So who else is going to provide the information? Your child is not a party to this action. You want contribution, you have to get the child's consent to provide the information. What do you do when the child says no? You don't get a contribution.
I think it depends on the circumstances. So I did do a motion fairly recently on the issue of disclosing where a child was attending school. And we ultimately prevailed on the motion. That would be ordinarily not something one would go to a motion on.
Right.
A parent is entitled at law to the information about where their child attends school. Even if there's no communication with that child, even if there's only supervised parenting time, they're entitled to that information. In the particular circumstances of this case, there were domestic violence factors where the children had been victimized, my client had been victimized, and she felt really uncomfortable releasing that information. And she felt really uncomfortable releasing her home address. We've probably dealt with that. If you've done any domestic violence work, you've probably dealt with the non-disclosure of the home address. So we didn't disclose the home address, and we did a motion on that. And then later we had to do another motion on disclosing where the children attend school. And my client her position was that the children attend school, and that essentially identifies the home address because of how catchment areas work. And the judge agreed and said, there's a history of stalking behavior, there's a history of abduction. It's not in these children's best interest to have that address released. And then our decision's actually sealed too. So
How old were the children in that case?
they were elementary school age.
Right.
So, and I think with an older child too, if the child has had a difficult relationship with the parent and has real reasons, right? So I think we're thinking of really extreme situations. In your typical, the child needs to release the information so that we can get some funding for post-secondary. That's a conversation with a very mature, potentially adult young person that your client needs to be having. And so if they say, well, that's not within my control, and the child refuses, there is information that the registrar's office gives to the parent paying the bill, right? So the universities have quite sophisticated ways of sharing some information, and so that information could be provided. I think there has to be a real reason to not disclose it. Attendance records is one that comes up in post-secondary a lot.
Yep.
And I don't know of many post-secondary programs that keep attendance records, right? So thinking is it a reasonable ask? Is it reasonable to get a grade report? It may not be. Successful completion of the program, successful enrollment. Thinking about whether someone is actually on a fishing mission just to get information that they may, in theory, have an entitlement to, or at law have an entitlement to. But if you're in an extreme situation, there are ways to defend against that, but you need to know that it's the right case to do that.
Yeah.
What are providers usually saying in what you've seen in the uh, re reality of these situations there?
So I think we all know some of this, right? We know that providers are confused. We know that providers don't want to be involved. Once they hear parties are in court, certain therapy practices say that my notes are not available to you. That's maybe not also true. They may have that written down somewhere, but that's not necessarily the case depending on the situation. But providers generally are confused. And when somebody comes into a therapy practice or a family medical practice or a school and is waving a court order that says, I'm entitled to this information, ideally they're running it with their internal counsel, right? So school boards often have a family lawyer on call or on staff, or a lawyer who has a lot of experience with family law in-house. I know the TDSB has family lawyers on staff, I believe. So they're hopefully running it by somebody. But if we word our orders properly, I'm saying orders here too, because I think most of these tend to not be negotiated settlements. They tend to be the higher conflict files. So if we're wording our orders properly, it should be clear to the provider that their home legislation still applies. And part of the problem here is that a lot of the precedents and templates we use, a lot of those standard clause orders, are not as clear about that. The Divorce Act precedents are, but the CLRA precedents don't specifically flag other legislation. So saying to clients, this is how this works, and writing our draft orders subject to the relevant privacy legislation really helps providers out, because then they know. And part of the guidance that I give healthcare providers is, if you don't want to get involved in these high conflict situations and you don't want to be making a lot of decisions about what information can be released and who's consenting to it, make sure you document in your notes who consented to a procedure, who consented to a course of treatment, right? Because then that's going to dictate who releases the information. So essentially, providers are confused. They want clarity from us. They would like it if our clients stopped coming in demanding information. And yeah, I think a lot of that is just laying it out in as plain text as possible.
But in those cases too, their commitment is to the person in front of them, the patient, right? It's not to the parents. Whereas in family court, you deal with the parents, and the test is also different. So we have to explain to our clients that the test in family court is best interest, but outside of that, it's maturity versus capacity for these practitioners. or maturity and capacity.
Yeah, and it's an issue, it's consent, right? So where it comes up for us is a lot around releasing information. And where the healthcare provider's thinking is more about who's consenting to the procedure. And the administrative staff in the office are dealing with our clients or us as counsel. And I would say that, actually, I forgot about our role as counsel because I'm so seldom in the information seeking side of this. But our role as counsel is to not overstate the law. And so I have seen emails that say, there's a court order, you must comply with it. Well, you're talking to a party who is represented, right? So
Yes.
if you are sending a copy of an order to a school administrator or a teacher or whoever it is that you are advocating on behalf of, I think we have a professional obligation, I know we do, to act as professionals and not bully these folks and say to them, there's a court order, I'm providing it to you, please let us know. And once there's a court order, and once they have a copy of that court order or they have that PDF attachment, they should be going to their counsel. And I can tell you, I have received that call because my name's on the other side of that court order with my phone number. And school administrators have called me and said, we have a court order here relating to this child. We're not sure how this ended up here. What are we doing with it? And I say, talk to your counsel, right? Because it indicates to me that the opposing party has delivered that court order to a school administrator and said, you need to comply with this. And I don't know if that's appropriate. I think that that should be going through their counsel, right? So same thing if you're dealing with CAS, sending very bullying emails and having difficult meetings with CAS workers. In my view, it's not appropriate. It should be going through their in-house counsel. And sometimes there's an urgency element, right? Your client emails you and says, CS was just at my house. Well, their in-house counsel may not be in the office. It may be after hours. Probably you shouldn't be taking that call either, but maybe you are for whatever reason. And you're emailing the worker. At least CC their counsel or flag to them. I know you have counsel. Please loop in your in-house counsel because obviously we don't always know who the lawyer is within the board. And for teachers, school administrators, principals, they tend to have more interaction with their lawyers. Teachers don't. So saying to them, flagging for them, could you please loop in your in-house counsel? I think we're required to do that. And I don't think it's appropriate to be sending orders with a process server and bullying third parties to try and release information that they can't necessarily release.
Sounds like the confusion exists as a result of the family court order giving a right to access to information that is subject to the institution, the healthcare provider, counselor, the third party having a legal obligation under the legislation to follow the steps to ensure that the child consents, understands, as you've outlined nicely, appreciates the understanding and consents for the release of the information. So if a parent has a family court order that allows them access to records, and they, as you've referenced, demand the records from the third party has legal obligations with respect to the privacy of that information for the third party to well, as family law lawyers, we know that the third parties are not involved in the family law proceeding.
Right.
So when we are negotiating and completing our family orders to family court proceedings, there's it's helpful, or a takeaway is to inform the client that there may be further steps, although the court order provides for the parents to obtain access to the records from the third party at the time that either parent takes the steps to request from the third party the disclosure of the records, there may be some further follow-up. If that's the case, and they send, for example, a parent sends a court order to a third party, provide the records, third party responds. It may be helpful for the family counsel to inform the client to circle back with the family law lawyer, at which point it sounds like the step would be to contact the third party to ask that that third party speak with their counsel so that their counsel could speak with the parent's family law lawyer. What really causes further confusion is that depending on which we're dealing with the school, we have the uh, school records, elementary school records, I believe are subject to municipal privacy legislation. The Healthcare Consent Act is obviously subject to the legislation that Andy referred to earlier. The children CFSA has its own, Section 308 has its own privacy provision. There's a number of points within legislation that various third parties may be subject to and bound by. And we can't anticipate, family counsel can't possibly anticipate each of the future instances of where a client may attempt to take the general standard 20 sub 5 CLRA order and provide that to a third party to provide the records. But there's a number of specific steps that it sounds like it still would need to be taken or addressed further to a final family order that provides for access to records. Is there anything more that was on the why the confusion persists? Is there, unless there's subject to anything more on that, then transitioning the law into practical guidance, including explaining issues to clients and professionals without oversimplifying things.
Yeah, I think we could oversimplify things, though. I think there's maybe not oversimplify things, but we can just simplify things right down to bare tax, right? So I think one, when I had a call from a school who said, look, like these parties are at war. Dad's been in here with a court order this morning. Mom's been in here screaming at us not to tell him anything. We don't know what to do. And I said, you need to talk to your lawyer, but that's as basic as it can get, right? And then she said, well, I'm going to talk to our lawyer, but does this mean we have to give him the school file? Because the opposing party was in there saying, I need your file. And I said, well, talk to your lawyer, right? Like I can't give her legal advice. But I think that we have a role here in telling our client, you're going to have to go through the same process as anybody else. You don't go into the medical practice waving an order around, demanding records. You're sending a request. You're waiting for their lawyer to look at it. They're going to figure out what you're entitled to. It's going to take some time. For those of you who don't typically do a lot of high conflict and then you find yourself in a high conflict file, just as a little tidbit that a lot of people don't know, it takes 18 months or longer often for children's aid societies to provide records. So the parties will sign mutual releases. Those are pretty low priority. There's an OCJ case that says basically stop it and says, well-heeled parties shouldn't come in here asking for disclosure orders to speed CAS up. Which I agree with, right? So CAS has a job to do. That job is not always providing records to us as much as we want it to be. So I think that's the piece of understanding what those timelines are. Release of medical records, release of dental records, release of a specific item might be quite speedy. So, and I think it's reasonable too to create orders where parties release information in their control. So we're not talking therapeutic notes, but things like professional reports. If your client has it in their control, it doesn't need to come directly from the third party in most situations, right? A copy should be sufficient. If your client is somehow editing report cards or editing, you've got a bigger problem, right? So thinking about where it needs to come from and who has it, and whether you can bypass some of these considerations. Thinking about, timelines. Just this morning, I sent an email to my local CAS council and said, I have a court date in 3 weeks. We're hoping to do this, this, and this. Can you do that? Is that too soon? What is your timeline, right? So working cooperatively with the players involved. I have the luxury of practicing primarily in Barrie and Bradford and Newmarket areas, so it's a fairly small jurisdiction. We have 2 or 3 CAS council. I know them. I email them. We have a collaborative relationship, right? Same with, I have a decent relationship with Toronto CAS as well. But in a bigger jurisdiction, you won't necessarily know who all the players are. And so building those relationships in your practice and reaching out to those information providers ahead of time, I think is really helpful. Showing up with a court order, great, right? You email it to their counsel, no big deal. But when your client is doing that on the ground, being able to say to them, hey, you need to email this disclosure department at the board, or my office will take care of it for you. We're going to send the order to them. They'll be in touch. And have your staff CC the client on it. So it sets the expectation that this is going through this particular part of this office. I guess understanding your institutions and how they operate. That's a piece of this.
But part of setting the client's expectation is having them understand a procedural right, which a CLRA gives them, and not a substantive right. And a lot of clients don't understand that.
Yeah, that's a good point.
In the Durham region, I find typically disclosure takes 3 months, which isn't bad. And generally you get it, right? If you do the proper consent forms, but if you don't, then the other side's information is redacted. So it's helpful to advise clients ahead of time as well that there is a proper way to do things, which is exactly what you're saying.
That's an interesting point. So yes, I should say that these are extreme cases perhaps where it takes 18 months to 2 years. So I'm thinking of files where there are more than 2 parties involved. So where there are 2 parties involved, the one way to speed that up, think about what the OCL does. The OCL asks for consent from partners as well. And then that speeds up the disclosure process. So from, I don't practice child protection, but a lot of my files overlap. And so I have a very good working relationship with particularly Simcoe Muskoka Family Connections and the Jewish Family and Child in Toronto. I've done a lot of work with them as well. And so I said to their counsel, I said, what can I do to make this easier? And she said, get consents from everybody you think might be in those files, because the less time we spend redacting, the faster we can get it to you. So if you know your client has a new live-in partner, so specifically for CAS, if you know your client has a new live-in partner, or the other party does, saying, can we get consent of all potential partners? And so that means having a conversation with your client. How far back are we going? Do we need CAS for the last 6 years? Do we just need it for this year? If it's a motion to change, maybe you're going back to the last final order. If there's an OCL report, you're probably not going behind that OCL report because they would have gotten that up-to-date disclosure. The reason the OCL gets it a lot faster is that they are not getting it redacted. They're having it provided to them unredacted. So it's the redaction that slows it down. And the more people who are involved or the more children who are involved, if you know your client has other children with somebody else, if CAS has been involved with this family, really do some digging to think about what's in that disclosure. I mean, it's kind of a trite advice, but don't ask a question that you don't know the answer to, right? And so asking for disclosure when you don't know what's in it, specifically from CAS, it makes sense to have a conversation with the client and say, how much have you been involved with CAS? How much has the other side been involved with CAS? Do you know which partner is their current partner? And just saying to the other side, this is the consent form. Doing that legwork ahead of time will also save you from doing it in the hallway at a conference. So reaching out to CAS as it comes up, I'm hoping to have this signed at this conference and bringing it to it. Knowing which CASs require a wet signature, believe it or not, some of them still do. So saying, I'm going to bring these forms and thinking about, how do you make that easy for your clients? Do you show up with stamped self-addressed envelopes so they bring it home? take it to their partner to sign, and then they are throwing it in the mail, so it's back at your office very quickly. Are you saying to them, have your partner sign it and drop it back by the office? It needs to be a wet signature. Are you pushing back on that with CAS and saying, one of these parties used to live in country, doesn't anymore? Do you really need a wet signature? Are you aware of the other legislation that has changed that? I try and get along with CAS, but just thinking through those procedural bits, right? Like when you're getting consent, who are you getting consent from?
Mm.
And how do you make this easier and faster?
Yeah.
Susanna, how might we be able to incorporate some of this into making more effective family orders?
Actually, Mark, I was going to say we touched on that and client expectations quite a bit. Andy, do you want to speak some more about the paramountcy issue and how do we deal with that? Because the Divorce Act specifically says subject to the legislation, right? But then they're all provincial. So is that effective at all?
Oh, I think the Divorce Act's handing that over to the provinces, though, right? So the Divorce Act saying subject to other legislation, it means provincial, it means a bylaw, it means potentially it means a school regulation. Who
Yeah.
knows, right? I'd love these kind of questions of the, what is the order of operations here? I don't know. I think the bottom line is we're talking about real world situations with real world considerations, trying to make it as clear as possible. For these larger institutions that are used to this, they have standardized orders. So Peel CIS, I hope nobody that has a Brampton file with me is on this call, but I try and avoid Brampton. But one of the things that they do really well in Brampton is they have a standard Schedule A that you can ask the judge to fill out at a conference. They'll offer it to you. I didn't know this the first time it came up. They said, "Hey, Mr. Inkster, we have a schedule for this." I'm like, "Great, let's get that attached to this endorsement." They have a standard Schedule A that has the CAS clauses that CAS likes. Make sure you know what those are for your local agencies. So if you're getting police records or CAS records, they will have standard conditions they want. Typically, it's that they're able to provide them electronically. Typically, they want 3 weeks. There's a bunch of things that they want. But having that call ahead of time or having that email ahead of time to their counsel saying, please provide a draft order for disclosure. In my experience, the police services are very happy to provide it. It occurs to me as we're talking about this that thinking about where that could come up to federally is if you represent clients who live on reserve or clients who live on army bases, where some things that you think of being provincial might be federal. But I do think it's okay. I think you're fine with the Divorce Act piece and the CLRA piece. I don't think it could cause, ultimately, I don't think people on the ground are necessarily thinking of it that way.
I've seen the Schedule A for CAS, not for other institutions. So, but that's really helpful to know. You can call them up and say, is there a particular clause that you would like included here? Especially when by conflict.
Yeah, and the way that this comes up actually is that often we forget, if we don't do this kind of thing a lot, third-party disclosure orders are binding on the third party. So this can come up with financial disclosure as well. And so I'm sure most of us have had the experience of an authorization direction to provide financial records. The bank just says no. Who are you? Right? The bank has its own thing that it wants. It's not happy. It wasn't party to that order. They don't care you have an order. They don't care you have an authorization direction. They want the client to come in. They need a month for their counsel to vet a POA, whatever it is, right? So just thinking about, how much of this can we do and how much of this we're expecting clients to do it and setting them up for success.
Yeah, because I've even had files where the other lawyer says, just have your client sign an authorization direction from my office to get disclosure from the bank. And I think to myself, I don't think that's workable. I don't think the bank is going to accept that. And so you have to do your due diligence and figure out what it is the bank wants. So you draft an effective order. Or maybe they say you have to bring a motion and serve us without notice we're not giving up anything.
Yeah, so I haven't actually done it with a bank because it came up on one of my files with CRA, where we needed certain things disclosed from an estate, and it was complex, and it was similar. We said to CRA, we need this, this, and this. They said if you're going to a motion on this is common for the police as well. I think it makes sense to reach out to them ahead of time, and you need to
Yes.
serve them. And then in the family law rules, they become a party to that motion, right? They are party
Yes.
added for the purposes of that motion. Talk about that in a second with children. But so for banks and third parties, they are going to have terms that they want included. Police CS, they do this all the time. They will say to you, these are the terms, as long as these are included in your draft materials, we will not take a position. So they're basically agreeing to it, right? So it's on consent of that third party. And that's the shortcut that Peel's doing through Brampton Court, is that they are saying, we have a sort of standing instructions that we don't take a position on any of these as long as it has a Schedule A and you're fine. So that's the issue. You reach out first and you serve the materials. You don't show up at the motion for disclosure on a third party, having not served that third party. And sometimes we're not thinking of it that way. So an interesting situation that I think is an emergent issue is, how do parenting orders work when children can vote with their feet?
Mm-hmm.
So when a child has autonomy, it can simply leave. And thinking about how that order gets enforced and what's the mechanism, and thinking about who those parties are, I think this is an emergent issue in family law. And I think particularly we've seen a cooling of judicial opinions on police enforcement clauses. They are less commonly used or less commonly ordered. Uh, Even on consent, right? The judge still has
Yes.
discretion if they're making that order or not. So thinking about how that impacts children who are maybe young teens, preteens, and up, is a policeman clause appropriate? That child is going to be taken into custody potentially by the police. Shouldn't that child be a party to that motion? There's an interesting piece there where children have some level of autonomy but are bound by orders. And this kind of gets into the domestic violence situation. Uh, thinking about that and thinking about how do we set clients' expectations? How do we respect children's autonomy and children's role in family court, especially when children are not represented? So if a child doesn't have OCL, or a child doesn't have their own counsel, and that's a strategic piece too, right? So for some clients, it's really important that the child be represented for them. They feel that's important. If OCL hasn't accepted the file, or they haven't accepted it yet, or a court has ordered it, but a party hasn't completed their intake form, so they've essentially vetoed the child getting counsel, or it's a very urgent matter, should that child be represented? I think that's something we should be turning our minds to, and we would be facilitating that in some way. Can a child reach out and hire a lawyer? Why not?
Just going back to that piece on the child apprehension orders under 36.2 of the CLRA. So we recently got a note from I think this is the York Region Law Association, the Ontario Association of the Chiefs of Police, sent out a direction to lawyers regarding the specific clauses that they would like to see in orders. And that's really helpful for family law counsel. So we can probably provide a copy of that to the attendees as well.
Yeah, that's an important point. And part of it is, it's their organizational preference of what they want to see.
Yeah.
But part of it is also, understanding a lot of us don't deal a lot with criminal law matters. Understanding what Section 7 of the Charter does, and understanding what that order does, and understanding what the requirements are. So if you're using a precedent and it has certain clauses in it or certain phrases in it, you're not sure why they're there, be very careful with orders that involve police. So the standard one is this order may be enforced at these times.
Yeah.
This order, so that's a pre-written search warrant. So it has specific implications if it's a night search or a daytime search, and that's why it has a termination date. So there's a piece there that we don't think of the charter very much in family law. We think
No.
of these as private disputes, but when you're dealing with CAS and police, you're bringing the state into it. You may also be bringing in the state through the education system. So thinking about how those pieces, these are not perhaps familiar things for us. Similar is true of restraining orders, right? So restraining orders are very specific contempt motions. They have specific quasi-criminal elements to them. Contempt is criminal potentially. So,
Mhm.
you know, if you're not sure, reach out to somebody, you know. I mean, certain people love a restraining order. And so, you know, I've acted as agent for restraining orders for people who don't do them a lot. And they said, you know, my office isn't sure, do you have precedence? I'm like, why don't you just get someone else to argue it for you? Like, think about that, right? Like, do you bring counsel in on a complicated disclosure motion? Do you bring in co-counsel just for that motion? It's not necessarily for the whole file, but do you take that one piece and say, are you serving your client well to say, okay, it's going to take me 12 hours to research this, or we can reach out to somebody I know who does this, and we'll do these specific bits, and I'll attend the motion, and I'll help draft the draft order. You know, there's pieces there that I think you can think about who to collaborate with and how to collaborate with them.
Mm.
Actually, while I'm thinking of it too, another one that comes up like that is special party motions. They're very specific because of the way they interact with the Substitute Decisions Act, the implications for POA matters. Like there's a lot of complexity to them. So bringing in co-counsel, if you're faced with some order or some motion that you're not really sure what you're doing, talk to somebody.
Mm.
Because it doesn't, I mean, I just think it doesn't look good when you do a motion on something or you do a draft order and then the third party says, but what about this, this, this? We can't give effect to this.
Yeah.
Been a full hour, very informative, a lot of takeaways.
Indeed.
I wanted to chime in about the banks. There is a section in the Evidence Act, as Andy mentioned. It's important to serve motions on third parties. For instance, the section in the Evidence Act and bank representatives are not compellable unless they're a party to the proceeding. It's very important to go into the formalities of serving motions and whatnot.
Andy, somebody in the chat was asking if you have a copy of the schedule for CAS handy that we can send out.
Oh, I have a photocopy of a photocopy of a photocopy of a photocopy. It's pretty grainy at this point. I actually recently took it and edited it so that I could send it to somebody to have it signed digitally or have it served. I can't remember exactly. We have it like it's physically at the Brampton court. I think just reach out. I mean, I hate to say this, ask the court office for it. But yeah, I don't have it's not just easily available. It's a challenging piece.
I'm trying to remember the last file I did this on, and I just it's evading me right now. It's been some years. So I'm sure I have it somewhere.
Probably the same photocopy of a photocopy I have. Yeah, the
Probably.
judge literally reaches to the court clerk if you're in person, which typically I was in OCJ in Brampton fairly recently on a motion, and the court clerk just has a stack of them and hands it out.
All right, well, without any further ado, we do have three audience questions that have been submitted. So the first question, what is the role of the attorney for property for a mentally ill individual? Can that attorney act on a child support case instead of the actual mentally ill support payor?
Well, it depends. I am so sorry, folks.
Answer.
It depends. Well, it depends on what that POA says. So is that POA effective, right? So actually this comes up a bit with wills too. So when does a will take effect, right? If someone's still alive, the will doesn't take effect. Doesn't
Yeah.
mean it doesn't matter, right? I don't know. I think that there's some complexity here where we don't always know we need these documents when a file starts, but we should be asking clients for copies of their will, copies of their POA. A lot of us have the standard closing in our file closing letter that says, hey, update your will now that you're divorced. Maybe we should be thinking about these issues a little earlier on, even if that's not our main area of practice, right? So back to the POA question. So it depends, because if the person has a continuing durable power of attorney where someone's acting on it, then that's different than if there are provisions about when that POA will take effect. The other issue that can arise is whether that POA is still effective. So if it's been revoked, you need to know these things. And so the answer is maybe.
Can a PGT push off a POA?
What was that?
Can public guardian trustee push off a power of attorney?
Push off? What do you mean?
Well, if the power of attorney is involved in child support and somebody reaches out to the public guardian and trustee, will the PGT be more likely become involved with the POA there or not become
Oh,
involved?
I
Or
see. No, they won't become involved typically if there's a POA acting, unless that attorney is removed. Or if the PGT has concerns about malfeasance by the attorney, they may begin a guardianship investigation. So I think that should always be where you start, right? A guardianship investigation where necessary. But if there's, I would say in the general case, if there's a POA document and there's an attorney who is acting, they should be handling the payment of child support. If they're not, then what are they doing for the person to whom they have a fiduciary duty? Right? So it gets a little tricky, but at that point, are they protecting that person's interest? Perhaps they are not. Or perhaps they're not paying child support because we've heard this from payers before. I mean, don't necessarily assume that a party paying through an attorney is any different than a typical payer who says, well, I'm paying my child support. I'm just waiting for Fro to start paying it for me. Right? And sometimes I think that arises because we think about the legal realm and we don't advise our clients properly and tell them, keep paying your child support. Don't wait for Fro to be beating at your door and grabbing it from your bank account and nabbing your tax return. I'm sure that for those of us who represent payors, we say this a lot to clients: is stay on top of it. You don't want to go into court being behind on your obligations. Uh, I think it's the same thing. You might consider whether that attorney understands that they don't have to wait for Fro. They should be making voluntary payments in the interim. It's also a situation where I think you could potentially ask Fro and say, hey, there's an incapable party here. It's a POA. They may not understand. And could you guys do a little something to get this happening a little faster? Because Fro's timelines right now, I mean, everyone loves to hate on Fro, but I've heard they are the most uh, despised agency in the Ontario Public Service. And I mean, I believe it. If recipients aren't happy, payers aren't happy, lawyers aren't happy, courts aren't happy. The number of times an order comes back and they say, we can't interpret this, and it's copied and pasted from the standard clauses. I think that there is some room there to do some advocacy or have the client call Fro and say, is there any way you can onboard us faster? Or say to the attorney, I think you need to get some guidance from Fro. Get advice from counsel too, referring the attorney to somebody and saying, hey, you need advice. Get them in front of somebody who does POA. Get them to contact somebody and find out what their obligations are, because I don't think they necessarily know what they are.
Tim, second question.
Our second question, why must a child be coercively made via court-ordered parenting schedule to visit with either parent in some addiction/unstable lifestyle?
Well, why? I mean, it depends. The court order is there in place for a reason, right? People sometimes agree to court orders. Sometimes courts order things because they believe it's in a child's best interest. Uh, court orders are in place. They're meant to be followed. If they're not being followed, there has to be a good reason and the proper mechanisms to return to court and have it changed.
All right. Our third question is, What are the reasons a lawyer may withdraw a SDO in high conflict?
Was it withdraw an SDO, like a support deduction order?
Yes.
Huh. Lawyer can't withdraw a support deduction order. They're required.
Mhm.
I mean, unless someone has a trick I don't know anything about. I mean, sometimes they
No.
don't get filed. Uh,
Congruence. It's not congruent with the law.
no. Sometimes they don't happen. I mean, I have had a few files where, and actually it's a good tip for recipient counsel. It took me a little minute to catch on to this. When you're taking on a client who was unrepresented previously, but the other side had counsel, go through your orders and double check, is the recipient getting the right support? I'm embarrassed that I didn't know to check that. I assumed that when the court issues a support order, that they're going to issue a support deduction order. And perhaps I overly generously assumed that payors counsel would file those. Some courts will do it for the recipient when
Mhm.
both sides are unrepresented. So I've had it where the support deduction order and the court order have been issued by the court because both sides are unrepresented. I, I mean, I don't think it's a good look. I don't think it verges on sharp practice to not do the part you're supposed to do. And I've had opposing counsel tell me, well, I think you should do it. You represent the applicant. And I said, well, the applicant was unrepresented at the time. Your office should have done it. I'm doing it now, but just sign off on approval of form of content. Don't go back and forth 5 times with me on it. Let's get it done, right? So I think there's an obligation there too on payers' counsel to make sure those get issued. As for withdrawing them, sorry, all that rant about when they're not in place. It's now on my intake list that we double check that every single order is being enforced by FRO. Um, I think in certain cases, I do recommend to clients to withdraw from FRO. I guess maybe the question is more accurately, should we withdraw from FRO? Uh, there are situations where clients may choose their peace and their safety over financial support. You may withdraw from FRO. You know that that means you're not going to get your support, but it maybe also means certain types of harassment might stop. Uh, Technically, we're not supposed to be able to do orders that say that a party no longer pays child support. Every once in a while, you get a really extreme situation where the opposing party wants to not pay child support and says, well, I'll give up all my parental rights. Okay, but is that going to be in a child's best interest? But is there a creative way to do it? So when the costs of parenting time are significant, so if a party lives at a significant distance, if a party is being expected to pay for a supervision service, that may mean that there's not really any money available for child support. So there might be a creative way, depending on the situation, to frame that. If that's really going to bring someone peace and safety, and my client instructs me to do it, I have ways of getting it done, or at least trying, right? An order is always subject to judicial discretion. Uh, I don't know if parties should withdraw from FRO. I think that having a third party doing enforcement for you is there for reasons. But is it a time when I worry about my client's safety? Is it a time that I necessarily know what's happening? No, right? I don't necessarily know when FRO is going to take enforcement action against the other party. Again, in my experience, my clients pay child support or they are not my clients anymore. So I don't deal with FRO very much on the payor side. But uh, for my recipient clients who've experienced significant domestic violence, I do worry. If we know that FRO is about to take someone's driver's license, if I know that those support arrear numbers, I'll do a quick calculation and I'll say to my client, you know, around this time, if he keeps not paying, around this time is when you can probably expect they're going to come for his license. And that tends to be a very dangerous time for clients. When garnishment starts happening, that's a time when a client needs a safety plan. And we may not be the right folks to help develop it, but telling them, hey, make a safety plan. Another common time is when criminal conditions end. So, you know, we often tell clients you don't need a restraining order because there are criminal conditions in place. But if you're not aware of when they're going to end, in my mind, I think you should be tickling those dates or at least informing the client, at this point, we expect the criminal conditions will end around X date, which is always subject to compliance and subject to jail time, etc. But around that time, the client who has been the alleged victim of domestic violence might need to be aware. And that might be a time where you're saying, okay, is everything okay? Or are we going back into court on a restraining order now? Right? So coming in on a restraining order and saying, there are criminal conditions in place, they are about to terminate, there's a probation order, we want these no contact clauses. You serve your client well if you can do that in advance, since you're not running into court on a restraining order because the opposing party showed up at the house and is now moving back in against your client's consent, and you can't do much about it except go back into court, right? So knowing in advance what's likely to happen and what's likely to provoke a client and what's likely to provoke an opposing party helps you do a lot of damage control.
Great, thank you. All right, we have one last question. We'll get this one answered and then we will wrap up. How does an 11-year-old be heard after voicing their fears, concerns, and wishes for the past 2.5 years to several professionals, but they still haven't been truly heard?
If you're in court, Office of the Children's Lawyer should be providing counsel for an 11-year-old or a Section 112 investigation. The issue that arises is, are a child's preferences and views well-founded, or are they taking on another parent's perspective or another person's perspective? So the contrast between alienation, where there's no basis for it, and reasonable estrangement, and whether someone can figure out which it is. Many of us have heard this from judges, and hopefully we're saying it to our clients too. At the beginning, kids want the parties to stop fighting. They want everyone to get back together.
Mm-hmm.
Then they want the fighting to stop. Then they want someone just to go away because they can't deal with the ongoing conflict. So if it's really high conflict for that long, then a child is saying, hey, I've grown up in this conflict, and rejecting one parent and rejecting the relationship may not be about that parent's behavior. It may be about the high conflict. They just want it to stop. And so thinking that through and setting clients' expectations. And I will say that in really complex situations where there's been a lot of, non-communication or non-contact, in my view, the best thing that the primary parent can do is ensure that there's a lot of parenting time, as much as possible, while keeping that child safe. So that child's well aware of who the other party is, and they have their relationship with that person to the extent it's safe. And if it's not safe, to spend a lot of time in person, maybe it's Zoom time, whatever is safe. So that prevents the other person from going back to court and getting a lot more. And it also means the child doesn't have an unrealistic view of who the other person is. If the other party is truly difficult to be around, a little bit of hard love and saying to a child, you need to spend some time with this person, you need to get to know them, because the danger is, if they are actually dangerous, that they become sort of a fantasy person, that the child is then very eager to get to know when they're older and may not know how to maintain boundaries with, and may be very drawn to, especially for, people who have magnetic or charismatic personalities at first. So that's a challenge, right? So allowing parenting time so that children can get to know everybody in their lives, for better and for worse, warts and all, that's, I think, a very protective strategy.
Great, thank you. Well, we are concluding our event now, so I would like to give a big thank you to our panelists for donating their time and sharing their knowledge today. All the resources mentioned today will be included in the show notes, which you will receive via email later this week. Thank you for joining and participating in Family Law Now, and we'll see you later.
Thanks, Andy. It's very informative.
Thank you, Mark.